registered, you must have your cell phone or any other electronic device turned off and put away. That includes lawyers and members of the public. You cannot use a cell phone camera or any electronic device to photograph, record, or transmit any aspect of these proceedings or for any other purpose while inside the courtroom. With respect to members of the media, there is to be no electronic recording or transmission of any bench or sidebar conference between counsel, or conferences between counsel and client. And if you're not operating one of the, I guess it looks like one, the specific camera that has specifically been permitted, you cannot use your cell phone camera or other electronic device to take any photographs.
2014-324, Commonwealth versus Carlos Ortiz. Counsel, please introduce us for the record.
Attorney John Connors for Mr. Ortiz, Your Honor. I'm here with my associate, Michael Maloney.
Good afternoon.
Good afternoon, Your Honor. William McCauley for the Commonwealth.
Good afternoon.
Shall I proceed with your record?
Yes, please.
Carlos Ortiz, indictment 2014-324-1. At the Superior Court Holden at Fall River, within and for the County of Bristol, for the transaction of criminal business on the first Monday of January 2014, the jurors for the said Commonwealth on their oath present that Carlos Ortiz, on or about June 17, 2013, at North Attleboro, in the County of Bristol aforesaid, did assault and beat Odin Lloyd with intent to murder him, and by such assault and beating did kill and murder the said Odin Lloyd, in violation of General Laws, Chapter 265, Section 1, a true bill signed by the foreperson of the grand jury and the Assistant District Attorney. Carlos Ortiz, to this indictment, how do you plead?
No good.
And the presumptive next dates. Is there a question of that?
Yes, Your Honor. We would just ask that the defendant be held without bail based on the new charge.
We would ask, Your Honor, he has been held on, for close to a year now, on $500,000 cash. And we would ask that remain in place. Other than the charges changed, none of the facts of the situation have changed, Your Honor.
Given the new charge, the defendant at this time is held without bail.
Judge, the presumptive dates are for a pretrial conference, September 24, and for a pretrial hearing, November 24.
Given the voluminous discovery you've already received, is there much additional discovery you're getting with respect to this?
I just received a number of discs, and I can't tell whether these are any duplications, but I received today a number of discs that I guess pertain to this case and a discovery.
Is there much additional discovery?
Yes, there is, Your Honor.
Do you see a realistic chance of advancing any of those dates from having a pretrial hearing earlier than and hearing on motions earlier than on November 24?
I didn't write down the dates.
The pretrial conference presumptive date is 9/24 and pretrial hearing 11/24, and I just wondered whether in terms of hearing on discovery and non-evidentiary motions, we could advance that before November 24.
At this point, I would like to leave those dates in place, Your Honor. Going forward, I have a home invasion trial in August, and I have murder trials in September, October, and November.
So I will leave those dates then, the pretrial conference on September 24, and and all mandatory discovery provided, and the pretrial hearing on November 24 with all non-evidentiary motions to dismiss or suppress, and any discovery 13D motions to be filed month before the pretrial hearing. The Commonwealth may file its opposition to those a day or two before the pretrial hearing. Now, there was, and is the, what do you propose with respect to the existing case of accessory?
Your Honor, I would ask that matter track the murder charge.
There's a motion for additional discovery of the polygraph examiners